Hi, my name is Mar Biernath. I'm an estate planning attorney here in the Atlanta area. And you're watching a several-part series on decision-making for incapacitated adults. And in this section, we're going to talk about what are some of the requirements to create or establish a guardianship or conservatorship here in Georgia, and what are some of the ongoing responsibilities of the guardian or conservator.
Okay, when do you need to be guardian? If the proposed ward cannot make or communicate significant responsible decisions concerning their health or safety. That is what the court needs to determine. They need to decide, is Joe capable of making a significant responsible decision concerning health, safety, or welfare? Making good decisions and being capable of making decisions is two different things. And, we kind of joke as lawyers that given the right set of circumstances, I can get anybody declared incapacitated, because we all make dumb decisions at some point in our life. That technically is not what the court is trying to determine. Just because you make bad decisions doesn't mean the court's going to declare you incapacitated. If so, there'd be a revolving door out of the bankruptcy court right into probate court. So people make bad decisions at times. Are they capable of making or communicating? The other issue is, can they communicate a significant responsible decision? And so that is what you need to prove when you go to court, that your child is not capable of making or communicating a significant responsible decision concerning health, safety, or welfare. If we're looking at finances, it's the exact same standard except it's decisions concerning their property. And they have property. So you may have a child who's not capable of making significant responsible decisions concerning their property, but they don't own any property, in which case you do not need a conservatorship. Why do you not want to have conservatorship if you don't need to have conservatorship? With conservatorship, you must post a bond. A bond costs money. That money is paid every year. So if your child doesn't have any property to their name, don't ask for conservatorship. If you don't ask for it, they're not going to give it to you, unless you're in Forsyth County. In Forsyth County, even if you don't ask for it, they're going to do what they call a backup conservatorship. Other courts handle it differently, so if your ward comes into property, there's an abbreviated way to say, okay, they now have some property. Do you want to name me conservator, or how are we going to deal with the property? So
you're talking primarily of real property?
Any kind of not personal assets like clothing, furniture, stuff like that, more financial assets or real property. For a guardianship petition, the petitioner has the burden of proof, meaning it's your job to convince the judge to do something. The judge is not there to do something just because you think it needs to be done. You've got to show the judge why this needs to be done, and it must be with clear and convincing evidence. For the most part, depending on your child, and when I'm representing parents who want to do the guardianship and we can bring their child into court, that oftentimes is the most clear and convincing evidence is to bring the child with you to court. And the judge can see, can ask questions, and that usually meets that threshold of clear and convincing. In one court, our hearing lasted 3 minutes. I introduced myself, my clients, and their son, and the judge said, okay, that's enough evidence. Let's move on. So, it's not always that simple, but sometimes it is. Once the petition is filed and the clerk accepts it, the clerk has to review the petition real quick to make sure it meets the minimum standards. Then, if it gets accepted and they file stamp it, then an independent evaluation will be ordered. The court might appoint the guardian ad litem. The court will appoint an attorney to represent the proposed ward, and at some point the court's going to schedule a hearing. And if the court only holds hearings 2 times a year, then it's going to be on one of those 2 days. If the court finds that the proposed ward is in need of a guardian, the court will then inquire as to who the most appropriate person is. Usually it's the person standing before the court saying, I want to be the guardian. But sometimes there might be more than one person who's standing before the court saying, okay, if you think they need a guardian, I want to be the guardian. Usually it's mom in the nursing home and there are 4 kids that want to be the guardian, but sometimes it might be birth mom and biological father, and one of them decided this is another opportunity to fight the custody battle that was lost several years before. So that's one of the risk factors where you might say, you know what, probably better to have an attorney involved. Or if somebody thinks this child comes with a lot of money, they might want to be that child's guardian. Those, again, are risk factors. For the most part, the families I work with, there's not a lot of money attached to the child. So that's a very low risk factor. The court does look to any advanced guardianship designations. Again, it's only a suggestion to the court. Conservators must post bond. If you cannot be bonded, don't bother applying. If you have certain criminal background, don't bother applying. What I like to tell people, if you have any outstanding warrants, don't go to court. You would be surprised how many people. Once the court determines that you are to be the guardian, then the clerk or the judge will administer the oath. It's a simple, I swear to basically take care of this individual and not abuse their funds and make sure they're taken care of. If you can't agree to that, don't bother. But I'm assuming that if you're here and you have somebody you care for, that would be the easiest part of the whole process. Then the court issues that all-important document, the letters of guardianship or conservatorship or both. That is your evidence that you are the decision maker. That's what you carry around in your wallet, you keep with you. You give a copy to every doctor that you might conceivably need to be with. The copy to the school system if they're still in school. Then the guardian and conservator has responsibilities. Those responsibilities are: must be available to the ward, must act in the best interests of the ward, must timely file all reports and returns. You do have at least, at minimum, an annual filing with the court. If you're not doing your annual filings, you better catch up. Some judges, not too critical about it, other judges will send the sheriff out to find you and issue a summons and have you come to court to explain why you haven't filed your return. This is just part of the oversight process. So then you also must inform the court of any conflicts of interest, including certain changes that the guardian may want to make. One thing that I know is kind of a sticky issue is if you plan to move the ward out of the state of Georgia, you have to get advanced permission from the court to do so. If you move within the state of Georgia, they don't seem to have a problem with it, because conceivably they can contact the sheriff of the new county and still pick you up. So, these issues are all related to jurisdiction, and they want to maintain jurisdiction over the guardian. Conservatorship is now a little more complicated. There is some expansion of authority. I'm going to kind of skip through conservatorship because it didn't seem like there's a whole lot.
I know where you now.
So in this section, we had an overview of what the court process entails and what the requirements for the guardian or conservator are. In the next section, we're going to take a closer look at what some of the rights and responsibilities are of the ward and some common misconceptions about guardianship in Georgia.